Hey folks, my name is Dale Davidson, the VA guy, and thanks for tuning in today. Today I'm wearing a little bit different hat to speak of. I'm not going to be talking about VA, so to speak, but more along the lines of, well, the topic is you're getting a divorce. What do you do with your estate planning documents? Okay, so what happens if you're going through a divorce? You're still married, but you're not actually divorced. What happens then, and then what happens when you're no longer married? What you got to do? Okay. So hey, look, if you like what we're doing here, please hit that like and subscribe button and the notification bell. That helps us a lot. Hey, got a little over 5,500 subscribers. Thank you so very much. I am blessed to have y'all watching. Thank you. So anyway, I want everybody to realize now we're talking about two different periods that you need to be aware of, okay? Because depending upon what period you're in, depends upon what happens with your estate planning documents, okay? So let's start with divorce pending, okay? Divorce, legal separation, whatever. So either you or your spouse has filed for divorce. Okay, that's the first period. Second period is the court has granted you your divorce or granted your spouse the divorce. So what happens then too? So what we're talking about is your basic estate planning documents, your durable power of attorney, your healthcare power of attorney, okay, living will, last will and testament, those kinds of documents, okay? And we'll be talking about those in those two different periods, okay? Now, remember, a durable power of attorney is a document whereby you sign giving somebody authority to conduct your financial affairs if you're not, say you're not able to, or you for whatever reason. Generally, they are revocable by you. You can tear it up. You can do a written revocation. You can tell somebody that you are revoking it, but you've got to do it in a certain way. Then the question is, what happens if you or your spouse files an action for divorce? Does that revoke it? Certainly, the divorce decree actually revokes that agency of your former spouse. Look, you don't want your spouse, who is soon to be your ex-spouse, the power to transfer your property, right? I mean, you want to control your property. So if you're going through a divorce, and most divorces are not very friendly, so to speak, so you certainly don't want your spouse taking advantage of the situation by using a power of attorney to transfer property away from you in this divorce proceeding. So, but I'm a belts and suspenders guy. So if you're going to revoke a power of attorney, and I suggest if a action is filed by either you or your spouse, okay, or you're legally separated, that you do a formal written revocation that is actually filed in the public records. So you'll file it just like you would a deed. So the whole world knows that it's out there. Okay? So, healthcare power of attorney. In Georgia, we call them the Georgia Advanced Directives for Healthcare. Same document. Okay? This is where you appoint someone as your healthcare decision maker if, for whatever reason, you can't make your healthcare decisions. So, pro tip number 2, okay? So if you're going through a divorce or an annulment or a legal separation, go ahead and execute a new healthcare power of attorney or a new Georgia Advanced Directive for Healthcare. Because just like the power of attorney, the durable power of attorney, you probably don't want your soon-to-be ex-spouse in charge of your health care. Again, it's personal, okay? So as long as you're legally competent, you can revoke your health care power of attorney. You can, just like the durable power of attorney, you can destroy it. You can revoke it by a written document, okay? You can do it orally. But again, there's some special rules with respect to that. And then it's automatically revoked upon the dissolution, the judge signing the final order. This is where we get into some differences in state law, and a lot of this is state law specific. So if you don't live in Georgia, you don't live in Florida, you need to check with your divorce attorney or an attorney and ask him or her this question. So in Florida, there's actually a statute that says if you or your spouse files for an action for divorce or annulment of your marriage, okay, or you're legally separated, that revokes the durable power of attorney, and it revokes the healthcare power of attorney. But that's not the law in Georgia. In Georgia, it says that you have to do a written revocation or, again, execute a new healthcare. If you are in the pendency of a divorce, you don't have the final decree yet, you want to make sure that you're protected, your assets are protected, and that your health care is protected, and that you're putting somebody who you trust, not your ex-spouse, maybe a sibling, maybe an adult child, or whoever that may be, to take care of your finances if you're not able to, or to make your health care decisions if you're not able to. Okay? Now, as part of this, we have the living will. So this is where you express your desires regarding end of life. So, for instance, if you're being kept alive by artificial means, such as a ventilator, feeding tube, etc. In Georgia, the living will is actually part of the healthcare power of attorney, or we call it the Georgia Advance Directive for Healthcare. Florida, it's a separate document. So, in Florida, the living will, again, is revoked upon the filing of the divorce, annulment, separation, whatever it may be. Not so here in Georgia, okay? Not so in Georgia. You've got to actually have a written revocation or re-execute a new power of attorney, a new advance directive, Georgia advance directive. So, let's talk a little bit about your last will and testament. Now, everybody knows that this is the basic document that everybody needs as part of the estate plan, okay? So this is where you specify who gets your stuff, your property, and how they're going to get your stuff, your property, upon your death. Maybe you have minor children, so everything would be in trust, okay? Maybe it's a second marriage, and so part of it is going to be in trust for your wife. Part of it's going to be in trust for your children or outright, however you want it, okay? So this is who is going to get your stuff and who's going to be in charge. Now, as a general rule, we have our spouses in charge of everything if we're not able to be here. They'd be in charge of our wills. They'd be our executors or personal representatives, okay? And you'll provide something for them in the will. Now, we're still in the pending divorce period of time, okay? So you would think that Florida would have a law, or every state would have a law that says, hey, your will is revoked as to your spouse if you or your spouse files an action for divorce or annulment or for legal separation. But that's not the case, okay? Your spouse's interest, or your soon-to-be ex-spouse's interest, you know, whatever they're supposed to receive under your will continues on until the judge signs on the dotted line saying that you're now divorced. So the problem is we're in the pendency of divorce. What happens if you die during your divorce? Well, your soon-to-be ex-spouse is going to get your property. You may or may not want that, okay? If you don't want that, here's pro tip number 3, draft a new will. Okay. Now, I would certainly suggest that you don't go to this LegalZoom.com or whatever, but go to an attorney who knows what they're doing. Because, especially here in Georgia, if you cut your spouse out, you've got to cut your spouse out correctly. Okay. So I would suggest some kind of language that, hey, I've got this new will and I'm not providing for my ex or my spouse because of this pending divorce action. Simple enough, okay? But again, get some legal counsel on that. So the will is revoked upon as to the spouse upon the court entering the order. It's not totally revoked, it's just whatever goes to the spouse is revoked, okay? So I had a quick story. I had a client over in Decatur County, Georgia, where the aunt actually went to the attorney's office after her brother had died. My client was a child of the brother, and so the aunt had gone to the attorney's office, got the will, and saw that the ex-spouse's name was still on the will and that she was going to receive his entire estate. Well, that she didn't want that. The aunt didn't. So she destroyed the will. Okay? Now, there's a lot of problems with that without going into it, but it created a lot of problems for my client because now we have to go in and do an administration, which is more costly and things of that nature. But the point of that story is that, look, I tried to convince the aunt that what she had done was wrong because the will as to the former spouse was revoked. Not the entire will, but just that portion going to the former spouse. So let's continue on. So let's talk a little bit about revocable trust, or we call them living trust. Now, these are documents that we create for folks here in Florida and in Georgia, and it helps to avoid probate, provide for some competent management if you become incapacitated, whatever the case may be. It's a really good estate planning technique. So, but the question is, we're still in the pending divorce time frame, okay? So is the revocable trust revoked as to the spouse, or do we have to wait till the judge signs off on the order? So, yeah, okay, cat's out of the bag. You probably already got the answer. All right, so the trust terminates as to the spouse, your former spouse, only when the court enters its final judgment. So until such time as they do, he or she is still named as a beneficiary of the trust. He or she could still be named as a co-trustee or a successor trustee of that trust. So it continues on during the pendency of the divorce. It lives on. Again, I recommend that if you've got a revocable trust, that you provide for, or you get your attorney, your divorce attorney, do an amendment to the trust, your revocable trust, saying, hey, I'm not providing for my spouse, okay, because of the pending action for divorce and annulment. And so then you can change that so that your assets will go to whoever you want them to go to under that revocable trust. Okay? So we've talked about durable powers of attorney, healthcare powers of attorney, living wills, last will and testaments, and revocable trust. Those are the, pro tip number 6, whatever it may be. I've lost count. If you're going through a divorce, okay, talk to your divorce attorney and say, look, I need to change all of my estate planning documents to take my spouse off. You may want to keep your spouse on, it's up to you. But if you want to make those changes, do it now. Once the divorce is over, go back and make whatever changes again. I know that's doubling up your efforts, but it's well worth making those efforts because that will protect you. You want to make sure whoever's going to be in charge is not necessarily your ex-spouse, and then whoever you want to get your property is not going to be your ex-spouse. So let's talk a little bit about beneficiary designations like life insurance, annuities, 401ks. And so when I'm counseling folks on this, I mention this and they say, wow, dadgummit, I hadn't even thought about life insurance or my beneficiary designations at work. So a lot of times that is an area that is outside the thinking. Okay, so many states have enacted laws saying that your former spouse automatically loses his or her designation as a life insurance beneficiary for the policy. Okay, but why take the chance? Okay, some policies are governed by federal laws preserving your ex-spouse's designation. For instance, ERISA. Okay, and that's not subject to some kind of automatic revocation. Now, ERISA is a federal law to provide for greater protection for spouses and dependents after a divorce. Now, one of these exceptions deals with a qualified domestic relations order, that is relating to your 401ks, your pension plans, your IRAs, and things of that nature. But to be valid, that quadro's got to meet certain requirements. A divorce attorney should be very familiar with those requirements. So, if you've got life insurance, even if it's life insurance through your employer, that small group term life insurance, if you've got an IRA, a 401k, whatever it may be, make sure that you've contacted everybody and say, look, I need to change my beneficiary designations and change them. Okay? Don't just say you're going to do it, do it. I'm telling you this because I have witnessed this with clients, and they're trying to recover life insurance after it's been paid to the ex-spouse. Man, that's hard to do. Because see, that insurance is a contract you have with the insurance company. And that beneficiary designation you have given to that insurance company says, by my contract, you're going to pay these benefits to this spouse. Well, this spouse may be your ex-spouse. Okay? And you may or may not want that. So just make sure that your beneficiary designations for all of your insurance, your life insurance, your IRAs, your 401ks, pensions, whatever it may be, annuities, okay, make sure that they are all up to date, okay? Now let's finish up with jointly titled assets, okay? So Florida, you can own a house, and we call that usually tenancy by the entirety. So it's your homestead, okay? It's in both you and your spouse's name. Now, in Georgia, when spouses own property, we use the term joint with rights of survivorship. They're basically the same thing, just different states, okay? You can have joint bank accounts and other joint assets as well. It can be joint with rights of survivorship, or it can just be joint, meaning that I own half and my spouse owns half. So it just all depends on how the asset is titled. So as you're going through the divorce, and you're talking about titles to cars, houses, boats, trailers, campers, whatever it may be, you've got to look at how they are titled and get those addressed early in on the process. Again, we're talking about during the pendency of divorce. If you own a house that's titled in both of your names and it's tenants by the entireties or joint with the rights of survivorship, it's going to your spouse. And that's okay if that's the way you want it. But if you want something else, you better dadgum say it. Okay? Talk to your divorce attorney, talk to a real estate attorney, see how that can happen for you. So again, joint accounts and assets remain that way during the pendency of divorce unless you do something different. So you can't, now don't go out there and start transferring assets because you filed divorce or your spouse filed for divorce, because you get in big time trouble transferring assets. Don't do that, okay? talk to your attorney, get some advice. So, we've talked mainly about the pendency and how that works. Post-divorce, once the court orders the final divorce judgment, you and your spouse, if named under power of attorney, healthcare power of attorney, Georgia Advanced Directive for Healthcare, living will, executor under your will, receiving anything under your will, receiving anything in trust, all of that is revoked as to your ex-spouse. So basically what the law presumes is that your ex-spouse predeceased you for purposes undertaken under your will or your trust or exercising any kind of power under your durable power of attorney, your Georgia Advanced Directive for Healthcare, whatever it may be. Now, the fly in the ointment for all of this pendency versus post time frames is the beneficiary designations. Remember, if you don't get anything out of this video today, get this. Make sure your life insurance, annuities, 401ks, and IRAs, make sure those beneficiary designations are correct and how they need to be. As soon as the divorce action is filed or shortly thereafter, make sure you contact your insurance agent, your employer, whoever it may be, and say, I need to change my beneficiary designations. Okay? So, hey folks, thanks for listening today, for tuning in. Hey, if you like what we're doing here, if you learned something new, and I hope you learned something new about beneficiary designations, okay? Hit that like and subscribe button and the notification bell. That helps us out a lot, okay? Let your friends and family know who we are. Tell them, hey, look up this guy on YouTube. If you need help with your estate planning, asset protection planning, VA benefits, whatever it may be, hey, contact us, okay? My Gmail account is dearvaguy@gmail.com, dearvaguy@gmail.com. If you have any topics you want us to address, leave some comments below or again, send me an email, okay? So, until next time, go out in this world confident in yourself with an attitude of gratitude and make a difference in someone's life. Thanks and be blessed.
No more whiskey, I'll have a Coke. Catching bass on an old fishing boat. One more story from Grandpa Joe. Let's get